Very good evening, delegates. Welcome to today's CPE meeting on arbitration opportunities for professionals. We have with us Advocate Satyanarayana to take us through this topic. May I now request Arun Ayampalayam Venkatesan, Secretary SIRC of ICAI, to give us a welcome.
Okay. Yeah. Good evening, sir. Good evening, all. Sir, I welcome our today's speaker Satyanarayana sir for the today's session, and also I welcome the participant. I think the arbitration is the new avenue available for chartered accountant. Most of us not known what are all the available opportunities available in these areas. I think the today's speaker Satyanarayana sir take through this, what are all the opportunities available as a chartered accountant in this particular platform, arbitration and other things. Sir, thank you, sir. Thank you for accepting our invitation, even though the small group of participants. So just I'll expect you what are all the opportunities available for us in this particular area, sir. Thank you. The floor is yours, sir.
Yeah, before I hand over the proceedings to Satyanarayana sir, it's my privilege to introduce sir. And before that, I request sir, with your permission, we are recording this session, and we are telecasting through our YouTube channel for the benefit of our members at large. Is it okay for you, sir?
Yeah, perfectly okay.
Yeah, thank you very much. Thank you for your nice consent, sir. Satyanarayanan Srinivasan graduated in Commerce and Masters in Law and Sociology from the University of Madras, and an associate member of all the three institutions with ICAI, ICAI, CMA, ICSI. Has done PG program in Treasury and Forex Management from ICAI, CISA from ISACA, USA, Intellectual Property Program from WIPO Institute, Geneva, and Graduate Certificate Program in International Arbitration from NUS, Singapore. Worked in large Indian corporates, MNCs, and banks for over 15 years in senior positions. Enrolled in the Bar Council of Tamil Nadu and Puducherry in the year 2001. Currently a partner with Wise & Worth, advocates and consultants. His practice area includes tax laws, IBCs, corporate laws, and intellectual property law. He is a regular speaker, appears before the Commissioner Appeals, ITAT, CESTAT, NCLT, NCLAT, and High Courts. He is a regular speaker at various forums on insolvency and bankruptcy code, tax, IPR and tech law, corporate laws, and topics of general importance, and is a regular writer in various professional magazines. Presently, honorary advisor for direct access to Andhra Chamber of Commerce, a member of expert committee in corporate law in Hindustan Chamber of Commerce. Presently, he is doing a research program, PhD in Tamil Nadu Dr. Ambedkar Law University on GST, Goods and Services Tax. With this brief, I present before you Advocate Satyanarayana sir to take us through arbitration professional opportunities available for CA professionals. Over to you, sir. Over to you.
Thank you, sir. Thank you. Let me at the outset thank the organizers, the institute, the office bearers, Arun and Mr. Rahman, for the opportunity given to speak on the opportunities available to the chartered accountants in the field of arbitration. Before we kick on, let me give you a old arbitration case that is recorded in the history of India, especially Tamil Nadu. The oldest arbitration case, now before we move on into arbitration, we need to know that, in simple terms, arbitration is nothing but a private court. Arbitrator is a private judge, and arbitration proceedings are proceedings in a private court. That's all. Why I say private court is because the arbitrator is decided by the parties. The parties have a free hand to decide the arbitrator. So it is not a formal court of law which decides the dispute, but between the parties, it is decided. Now, when we say this, that the private parties decide the arbitration. So it doesn't go to, in good olden days, what used to happen is that kings used to sit in court as judges, or he appoints a minister specifically for this purpose, and that minister decides as to he'll decides disputes, and he's in modern parlance referred to as the judge. Now, any person other than the king would not be called a judge, because he will not have the authority under law to decide cases under the authority of a king. So that is not a case at all. No. The oldest one that we know of in the recent times is in the early 1807. 1807. It's interesting. You know a raga called Shankarabaranam. This raga, I mean, it has a lot of healing effect, in this raga. So what happens is that, there was one person by name Subbayar. He used to be in Tanjavur area, and he was so famous in Shankarabaranam raga. It has a healing property. So he was so famous that the king of Tanjavur, bestowed him a title saying that, he is Shankarabaranam Subbayar. That's the name given. That much he was famous about that particular raga. Now, what happened is that he wanted money very urgently, and he took loan from a jamindar in that particular area, known by name Mr. Mupanar. So he didn't have any other movable property. So he gave an undertaking to the jamindar for the amount that he took, that he will not sing Shankarabaranam before anyone unless and until he repays the loan. This was the word that he gave. He became so famous that the governor of Madras that time wanted, wanted to arrange for a concert with the singer. So that was arranged, and the request came that he should sing Shankarabaranam. This guy refused, saying that, I cannot sing because I've already given undertaking. It's more like a pledge. Being an immovable, intellectual property, I cannot go ahead. Now, this issue was arbitrated out. This issue was arbitrated out and settled. Now, this is the first known arbitrate issue in the modern history. Now, when I say this, arbitration is not new to India. We find traces, research says that, we find traces of arbitration, initial evolution of arbitration in India, way back in the Upanishads, in Brihadaranya Upanishad. It has reference to arbitration, where they had local court, then an arbitration where people engaged in the same business of profession would arbitrate issues amongst them, and then a panchayat. This was the legal system that was existent, which is recorded in Brihadaranya Upanishad. These are part of research findings, that have come out. But when we talk about arbitration, the first word arbitration and arbitrators were used in 1858 in an English case called Collins versus Collins. Now that's the well-known case, where this arbitration came in place. Like in India, as a legislation, the arbitration came in 1899, first one, and that was applicable only to the three presidencies: Bombay, Madras, and Calcutta presidencies, not outside these presidencies. And then, it was replaced by Indian Arbitration Act 1940, which again, when an arbitration award is passed, you have to go, that has to be confirmed by the courts before you could proceed. And there was an appeal also allowed on the arbitration award. This applied to the whole of India. Now, after this, this was replaced by the latest enactment in 1996, Arbitration and Conciliation Act, which is on the UNICTRAL model of the UN. Now this is the broad understanding that we need to have when we talk about arbitration. Give me a minute. We'll go here. So with that, so arbitration, like, Mr. Arun explained that, it's not new. We have, but it's a good practice to start with, where, a new avenue of practice for chartered accountants to move on. And more so now, because of the emerging, changes that are happening in the foreground and also in the background, in the business scenario. Now, I was referring to the arbitration practice in Brihadaranyaka Upanishad, in which what used to happen is that, if a particular business person has a dispute, then they would appoint one among them to adjudicate the dispute. Now, for example, if one businessman borrowed money from another businessman, another businessman will be appointed, a neutral person will be appointed to adjudicate the dispute that these two people have had. Now, that's how it was, in the arbitration also. Now arbitration is part of a bunch of system called alternate dispute resolution. The world is moving towards, what is classical area. From that, the world is moving away from, the classical area. And just to tell you how they are moving around, even if you look at the modern medicine that we have, people want alternate to that. That's why you have alternate medicines, which is now, and when we go to West, it's very famous, and it's also picking up under Ayush in India. Now that's happening. Now, similar to that, in dispute resolution also, now we have an alternate dispute resolution mechanism, which is what you find here. One is litigation, which is like, deep sink into, and it's happening, it will keep happening, it will all happen. Now, the other way to look at it is to resolve dispute is a mediation, a conciliation, which is more a facilitation, then negotiation, then arbitration. Of all these, these are the alternates that we have now. But all these are not the same, and all these, differ from one from the other. Facilitation or conciliation is allowing the parties themselves to sort out the issue. Now, while mediation is for a person to come in between and try to mediate, try to settle the issue among themselves, but he doesn't adjudicate. That's where, we need to understand the difference between arbitration and mediation. Now, negotiation is where you negotiate, you get. In all these, if you look at the role of a chartered accountant, is more in a negotiation and in arbitration by far, than the other two alternate ADR mechanisms that we have. Now, how do I define arbitration then? Is that arbitration is a procedure in which dispute which is submitted by the parties based on an agreement is adjudicated by one or more arbitrators, and the decision of the arbitrators are final and binding on the parties. So the whole of arbitration is an adjudication process. It's a procedure to be followed. The emphasis is on procedure because we'll see that today, unlike the 1940 Indian Arbitration Act, we don't have an appellate remedy against an arbitration award. At most, what can be done is an petition can be filed under Section 34 of the Arbitration Act 1996, to set aside the award. And how can it be set aside? On what grounds it can be set aside? On wrong procedures being followed. That's all, nothing else. You can't reappreciate evidences. As we go along now, I'll just tell you as to why it is and where it can stand. Simply put in, people choose their own, private court for dispute resolution rather than going to a statutory court established by law. That's what happens. So they choose their own judge. Now, what is the role of a chartered accountant? In put it in simple, is that these are the three broad roles that a chartered accountant can play in an arbitration. Now, we are not talking about mediation. We are not talking about facilitation, which is conciliation. We are also not talking about other alternate remedies that are available. We are talking purely from a context of arbitration. Now, a chartered accountant can be an arbitrator to start with. And which industries where he can become an arbitrator, we look at that. And second is that he can be an expert evidence in an arbitration proceeding. Third is he can render support service like valuation, loss of profit, calculations. These are few things that he can do, or he can come and work around with few figures that goes out of hayway, fraud reporting. All these are the support services which can be worked on by a chartered accountant in the process of arbitration. Now, broadly, why arbitration, why not litigation, is that an arbitration is a private proceedings. When I say private proceedings, what do I mean is that it's going to be confidential. The issue, the dispute, the parties are not going to be divulged, so that it can remain private and it can be confidentiality can be maintained in case of arbitration. Whereas when you look at litigation, it's in public domain. So if somebody applies and takes a document, nobody can say no to it. And that's what happens. Look at if resolution plans are approved, resolution plan can be looked at by a third party. You can't say that it's a private document. Whereas a shareholders agreement, when it is not in this thing, that cannot be looked at. Right? Second is, when it comes to courts, only judges decide, and judges come from the legal profession, and they are strict. They may be good in law, but not in the functional subjects. Now, that's why when you look at earlier, there used to be chief managers or deputy general managers from banking companies will be appointed as the preceding officers in DRT, Debts Recovery Tribunal. Now, that practice is also stopped now. So, but when it comes to litigation, judges alone adjudicate. When it comes to arbitration, the expert in that particular field can come and adjudicate the issue. Now, third important thing is in enforcement. Now, when it comes to arbitration, internationally, it can be enforced by virtue of the New York Declaration and Treaty. Now, when it comes to litigation, the bigger question is, can foreign judgments be enforced? Is a big question. Among Commonwealth countries where there is an exchange of treaty on judgments, the CPC in India allows execution of foreign degree. And there are also conditions attached to it. It has to have reasoning. It should not be opposed to the policy of India. All these issues are also there, which has to be complied with, before court order or a decree can be implemented internationally. But when it comes to arbitration, it can be just enforced across in any country. Now, if you get an award here and you want to go and execute it in US, it's easy to do it. It's easy to do it. Now, what are the characteristics of an arbitration? As I told you, it's a private proceeding. So trade secrets, know-how, what happened can all be kept confidential within the four walls of a room where the arbitration is happening. And it has to be kept confidential, few information shouldn't go out. Business related disputes. Now, parties are free to appoint the person whom they trust to be the arbitrator. A person could be, well known in the industry. Probably his intervention could resolve disputes. He can also get appointed. There is no specific qualification other than integrity and independence is required for an arbitrator under law. An arbitrator can also be an expert in the field. Like, say, for example, if there is a maritime dispute, a maritime engineer can be an arbitrator, sit and decide on it. We were handling a arbitration with ONGC. Now, people who know about offshore logistics and people who are well versed in oil drilling, they were sitting along with a judge. It was a panel of three arbitrators. They were sitting along with the judge, with a retired, High Court Chief Justice of an High Court, as an arbitrator to, adjudicate the issue. So it becomes so easy. Specialized knowledge is there. Now let's say example, there is a dispute amongst the partners, a partnership dispute. A person who knows accounts would be best suited to be an arbitrator because of the virtue of his special knowledge in accounting, which is a core dispute area among the parties. Now, prior to 2015 amendment, what was happening is that this Arbitration Conciliation Act came in 1996, and for the 20 years, they looked at, though arbitration was said to be, less costly affair, but sometimes, arbitration was looked at as very costly affair than litigation in courts. Like arbitration, there are arbitrators who charge about 2.5-3 lakhs per sitting. Each arbitrator charges, that could be. Second is, there are a lot of court interventions that were happening. Now that is also restricted. Now you have court intervention only in section 8, where there is an arbitration agreement. It needs to be referred to an arbitration. Courts cannot proceed with. Now you have court section 9, which deals with pre, during, or post arbitration intervention of court for interim orders. Then you have section 11, subsection 6, where arbitrator appointment comes in. Then after that, arbitrator himself is given power under section 17 to give interim directions. Then you have to go only, court intervention comes only in section 34, where final award is passed, then to set aside that award, you can apply to a court. Now, section 37, where an appeal can be filed against an interim order of an arbitrator. These are the interventions that are possible now. Now, third was the arbitrations, the average time of litigation in India estimated around 2012 is about 18 years, where it involves property disputes and other disputes. Now, that when it comes to arbitration, though it was faster, but it was not that fast as expected. Now, when somebody goes and uh, does an court proceeding in a country like Singapore, it takes about 2 years for an litigation to get complete after all procedure. Now, when it comes to arbitration, they do it in 6 months' time. Sometimes lesser than that. Sometimes it goes little way by 9 months. But in India, it was taking about 3 to 4 years, and they were all going. The process was long drawn. There were a lot of delays in arbitration. Now, so what happened is that to cut all these short, an ordinance was brought in October 2015, and then an amendment also came in, and the amendment was made effective from 1st January 2016 onwards. And these issues were flagged by the Law Commission in its 246th report. Based on the recommendation, it is done now. Now, arbitration fees are fixed now. Supreme Court goes on to say that arbitrators should not get themselves in unless the parties agree on the arbitrator's fee. The second thing, important thing that needs to be looked at is that now a time frame is fixed, 6 months, and another extension of 1 more 6 months can be given. That's all. Before that, the arbitration has to complete. If it is not completed, what happens is that the dispute is not resolved. Then the very purpose of getting into arbitration is gone. Because if you look at today, CPEs is amended in case of commercial disputes. You have Commercial Courts Act and Commercial Courts established, where the procedure is very easy and it draws in the case management a system comes in, and cases are decided then and there immediately, and the disputes gets resolved maximum by 2 years time. So when that be the case in case of a litigation itself, then arbitration should be much faster. So that's why they put 6 plus 6 months of cap in arbitration proceeding. And where all judicial intervention is possible, Section 8, as I said, for making a reference in case of a pending suit, 9 for passing interim orders, 11 is appointment of arbitrators, 27 is where assistance of court can be taken in taking evidence. Now, sometimes what happens is that you send notices are sent because summons cannot be issued by arbitrators. Only notice can be sent. When notices are sent, sometimes they may not turn up. Sometimes you might have to issue subpoena process to a third party who may not be interested. In those cases, the assistance of court can be taken under Section 27. 34 is to set aside an award, final award which is passed. 36 is for enforcement of an award. 37 is for appeals against an interim order issued under Section 18. 39(2) is for directing delivery of an award. And then, in case of disputes in insolvency proceedings, 41 comes into play. Now, prior to 1996 Act, which is prior to the current Act, Supreme Court in case of Guru Nanak Foundation versus Ratan Lal Singh said that the way in which the proceedings under the Act, this Act is the Indian Arbitration Act 1940, are conducted and without an exception challenged in courts, has made lawyers laugh and legal philosophers weep. So this was a time when you had every award of an arbitration tribunal was challenged in appeal. Now, the essential difference between an appeal and a procedure contemplated under Section 34 are completely different. In case of an appeal is normally a continuation of the trial, which is the actual adjudication mechanism, the original adjudicatory mechanism. It's a continuation. So when an appeal is filed, similar to that of appreciation of evidences, the arbitrators can also reappreciate. The courts could also reappreciate evidences. In 1940 Act as appeal was allowed. Now, when it comes to Section 34, there is no reappreciation of evidences and all. You can't do anything. No appreciation of evidences, nothing of that sort. Whatever the arbitral tribunal decided on facts, that alone. Even a question of law can also not be agitated before a court under Section 34. What all you can do is that specifically mention in Section 34, and to that extent alone, petitions are admitted. Though in practice, sometimes you find anything get admitted, but largely from a larger perspective, only when there is a procedural lapse that happens, a Section 34 petition is maintainable. Now, what are these? Is that a party to the dispute under arbitration did not had any capacity to contract, because the contract itself is void. Now, second is when the matter is not arbitrable at all. We'll see what is that. The third one is that proper notice is not given before appointment of arbitrator, or the arbitral proceedings, during the arbitral proceeding, the notices were not served properly, which is again procedural. The fourth one is that disputes which are beyond the scope of arbitration agreement, where there are agreements which of arbitration which are very restrictive in nature. Now, these are what can be disputed in Section 34. In addition to these, matters relating to which are in conflict with public policy of India can also be disputed under Section 34. So there is no reappreciation of evidences. So it has put an end, the 1996 Act has put an end to an appeal against an award passed by the arbitrators under the Arbitration Act 1996. So now it has come on track with others. Now, what happens in an arbitration? Generally speaking, in an arbitration, where there is a difference or dispute amongst the parties, to start with, it refers to an arbitration. How it refers to an arbitration is that you issue a notice saying that you want to initiate arbitration proceeding against a particular party because of a particular dispute. And then the arbitrator is appointed. Say, for some reason, an arbitrator is not appointed by the parties. Now, arbitration can be, now let me say this, before I move on. Arbitrations can be broadly into two categories. One is ad hoc arbitration. Second one is institutional arbitration. Now, institutional arbitration is like, ICC, International Chamber of Commerce Arbitration, SIAC, Singapore International Arbitration Center. Now we have one in Hyderabad now, Hyderabad Center, now, or London Court of International Arbitration. Now, these are institutional arbitration. Other than this, picking anyone to be an arbitrator is called ad hoc arbitration. Now, so what happens is that, if you don't agree on the arbitrator, if it's an institutional arbitration, it would automatically provide you a mechanism as to the appointment of arbitrator. If it is not an institutional arbitration, then people have to do it, and if they dispute, they can go under section 11 to the Chief Justice of the High Court or to the Chief Justice of India, and then seek an appointment of arbitrator, and arbitrator is appointed by them. Parties are also free to appoint anyone to be an arbitrator. And second is that if parties don't agree otherwise, under the Arbitration and Conciliation Act 1996, arbitration is through a sole arbitrator. Parties can agree on 3 arbitrators, 5 arbitrators, 7 arbitrators, any number. Now, in case of 3 arbitrators, which is a arbitral tribunal of 3, then one arbitrator is appointed by the claimant, the other arbitrator is appointed by the respondent, the third arbitrator is appointed by the 2 arbitrators themselves. And that's how a reference is made, the arbitration is done. Then the arbitration proceeding starts. And what is the arbitration proceedings? Is that to start with, a claim statement is filed by the claimant. Then the defense statement is filed by the respondents to the arbitration. Then there will be acceptance or denial of documents. Then either party or both the parties are allowed to give evidence, which could include oral evidences. In case of an oral evidence, there will be a examination in chief, cross-examination, and re-examination of the each witness. And then, after the evidence stage, the arguments happen. After the arguments, all these are under the arbitration proceedings. Okay. Now, after the arguments are complete, sometimes, oral arguments are submitted. And sometimes, they'll also ask you to submit a written submission. And after that, an award is passed. Award is the final. In between, if interim directions are required, directions can be sought and can be, executed in the interim to safeguard interest, like, as to cost, as to, security for the disputed award. All these would come in. Now, after making of an award, the award has to be published, only then it becomes final. If, let's say, for example, what is publication is to, it's not, to the public notice, but at least, it is informed to the parties to the arbitration. For example, there is an arbitrator, Mr. X, who decides, who hears, who appreciates all the evidences, looks at, all documents, all that. Finally, he writes even the award. The award is ready, kept. He has signed the award, but unfortunately, before it could be posted out, he passes away. So the award is not published at all, it's not passed on at all. Then what will happen is that the whole arbitration goes for a toss. It needs to be started again, because unless and until it is published, it will not have an effect. It will not have an effect. So the day of publication of the award is the relevant date to make a petition under section 34. Now, after publication, either the award can be challenged under section 34, or an award can be enforced through a civil court, as if it is a decree passed by a civil court. That's the whole arbitration, the way it will function, or how the awards of an arbitration are enforced. Now, before we move on, as I told you, the two roles, rather three roles that a chartered accountant can play is one. The first one is that of an arbitrator. Now, and for an arbitration to start, there has to be an arbitration agreement. Section 7 of the Arbitration and Conciliation Act defines what is an arbitration agreement, or rather, it specifies what an arbitration agreement is all about. Now, it means an agreement between the parties to submit either all the disputes or some of the dispute that has come or that has arisen between them, whether under contract or not, to arbitration. Now, arbitration agreement can be in the form of an arbitration clause in an agreement itself. Now, let's say, for example, a railway contract tender. Okay, in case of a railway tender, what happens is that the standard terms and conditions to the agreement (LOA) contains arbitration clause. Now, if you look at it, it is not referring to all the disputes. Only certain disputes are covered under arbitration. Balance, it is not covered, and it has to go through the litigation route, regular litigation route. That's how it is done. So there could be arbitration agreement could also be a clause in an agreement, or it can be a separate agreement per se. Now, what is important is that arbitration agreement has to be in writing. There is no oral agreement that can be reached, though the Indian Contract Act says an oral agreement is also an agreement. This is similar to that of trust need not be registered, but to avail section 12AA registration, or to claim deduction under section 11, immunity under section 11 of the Income Tax Act, we say the trusts have to be registered. Similar to that is that here it has to be in writing. Now, it cannot be from one person. It can also be through exchange of letters between parties, or by email communication exchange is also fine, or even exchange of statement of claim and defense, in which a dispute is in existence and is not denied by the other party, even though there is no arbitration clause, then that would also amount to arbitration agreement. Now that we know, Supreme Court in Rickness Wilwarton versus Indian Oil Corporation way back in 1998 held that what is important is the intention of the parties and the meaning that it is conveying. Now, arbitration agreement can be a statement by one party regarding his claim in dispute, and it need not be denied by the other party. Only then, arbitration agreement comes in. Arbitration agreement is the basis on which the arbitration is proceeded with. Now, as I told you under section 34, there are certain non-arbitrable issues which can never be arbitrated. It has to go through the normal judicial process, either to the civil court or to NCLT, in case of to this thing, or to family courts or to labor courts. That's how it has to be. Now, all these disputes, if you look at, would be disputes in rem and not in personam. Now, what are these disputes? Like, criminal cases, intellectual property cases, insolvency, statutory legal material, oppression and mismanagement, matrimonial disputes, and labor disputes. All these are not arbitrable at all. All these disputes can be only adjudicated through the normal formal judicial process. Now, another important thing as arbitrator, what we need to know is that in case of an arbitration, there is a subtle difference between a seat, venue, and place condorum. It's very important. Now, a seat is the situs of arbitration. Now, what do I mean by that? It means that the law of the seat of arbitration would naturally apply. Now, you will ask me a question. Sir, I have a dispute. Two Indians have dispute in India about a particular case. Can he have arbitration in USA? If people choose to, and if the agreement provides that the seat of arbitration will be so-and-so place, say for example Singapore, or they say that Pattaya, then the arbitration has to be the state, situs of arbitration has to be Singapore or Pattaya. It cannot be different. Now, this is important. Now, place is different. Our venue is different. What it means is that, I can, when it comes to seat or situs, the law of that particular country applies. Where, now, for example, I have a dispute, say with MANC, let's say Mano Corporation, okay, Mano Corporation. And Mano Corporation, let's say that, it's there in Chennai, the other part of Chennai. Now, I'm also in Chennai, it is all in Chennai. In that case, what happens is that the parties can agree to have arbitration in Singapore or Maldives or Mauritius or in any other place. That's the importance. So a place or a seat of arbitration would mean a judicial state seat of arbitration, judicial seat of arbitration. So that's where the jurisdiction comes in. And the law in those arbitration, relating to arbitration in that place would equally apply toward and not any other case. Now, two important cases, that are important for us, to understand. BGS Soma judgment is very important. This is a joint venture case between BGS and SGS Soma. Now, this was rendered in 2019 by the Supreme Court. Now, this is very important because in this, the court have clearly said the law must be stable, and yet it cannot remain still. Stable is different from stillness. Stillness means frozen, dead, no evolution at all. Stable means it is stable, moves on. Now that's major, this thing. And in this case, the venue of arbitration designated in the arbitration agreement between the parties is the seat of arbitration. That's what Supreme Court had said in this judgment. It's a three-judge judgment of the Supreme Court. Now, what has happened is that this is overruled a very large number of decisions of Supreme Court otherwise. Now, Dawoodi Bora community versus state of Maharashtra is another judgment in 2005 by the Supreme Court, where they said where the issue came in for a petition to reconsider the earlier decision of a constitutional bench of a strength of 5. They've said, it has to go to a 7-member. Now, what they've said is that the rules will not affect the discretion of the Chief Justice of India. And he is the sole person to decide to which bench, which case has to go. So that assumes very importance, in the whole thing. Now, so the important thing that comes out is that from BGS Soma judgment is that the seat of arbitration will be the venue of arbitration. Both are same. Seat and situs should not be confused and should be given the same importance. Now, as opposed to this, there is another judgment, the Supreme Court, which is in Mankatsu Impex. In Mankatsu, Impex judgment. Now, what we need to understand is that before that, let me tell you this. This is very important. Okay. Now, BGS Soma joint venture, judgment, she saw. place, choosing a place would amount to the seat of arbitration. And that, in that, they followed the Bharat Aluminium case. So they said, when you combine with the rules, would decide, what will apply. But in Mankatsu Impex, there is again, a clarity which was which was lacking to be brought in, which said the MOU mostly said that it is governed by the laws of India without regard to its conflict of laws provision, and courts at New Delhi shall have jurisdiction. This is what it said. And then it went on to say the arbitration shall be finally resolved by arbitration administered in Hong Kong. The place of arbitration shall be Hong Kong. That's important. No, that's the this thing important that we need to know. Now, in Soma, BGS Soma judgment, Supreme Court said, now this is important when you sit as an arbitrator, because you need to decide which laws to be applied on, which country's laws should be applied on. So that becomes very important. Now, in case of Mankatsu, you said, laws, jurisdiction of Delhi, but arbitration procedure followed will be that of Hong Kong. So here again, the issue came up as to what they refer to. What they refer to. So they here, when you place seat, we're all different. So this has to be differently looked at. That's what we need to understand. It cannot be same with that of BGS Soma, because the agreement is different, the arbitration clause is different. Depending on that, that needs to be done. Okay. Now, venue can be separate basis, and it can be a convenient place. Let's say, for example, I might say laws of India will apply, but I can have arbitration in Andamans, or I can have arbitration in Paris, Swiss. It wouldn't matter at all. Then Indian laws will be applied. Only thing is that the arbitration proceedings will be carried out in Swiss or in Paris or in Andaman or in Mauritius. I just wanted a cool location where I can go sit, decide, I can still keep doing it. That's all. Now, what are the powers of an arbitrator and duties of an arbitrator? Because we are talking about a role that chartered accountant can play as an arbitrator, being an opportunity for a chartered accountant. In that context, we also need to know what are the powers of an arbitrator. He can pass interim orders. He can decide the process of arbitration proceedings. Now, he can sit, because the provisions of Civil Procedure Code does not apply in case of an arbitration, nor does the Indian Evidence Act provisions, do apply. But the rules of evidence would naturally apply, and the natural justice principle would apply. And then he has the power to terminate the procedure as well whenever wanted. He can appoint an expert person and take advice from an expert person if it is required. Seldom it is done, unless it is an international arbitration. He can also seek court permission in taking evidences. We saw section 27, where it can be applied to court to get protection, to call for witnesses. And in case of an error, after passing of an award, he can correct that as well. These are the powers of an arbitrator. Now, what are his duties? In addition to that, he can award interest. All that goes in as part of the award itself. But what are his duties? Now, duties is the order of appointment. When it gets done, what will be his role? All that will be there. The second one is that he has to adjudicate the issue in a time-bound manner. And third is that he has to act independently without any fear or favor, and all his exercise of discretion has to be judicious, and it cannot be lopsided, it cannot be one-sided. It can happen. Now, he can, during the course of arbitration, he can also encourage settlement between the parties. He need not, go through the mill fully. And then, he can pass, he has to pass a final award. That's very important. He needs to do that. That's very important. Now, if it's all clear, what I'll do is that, I'll keep moving on. I have a 1 minute. I'll just look at any question that has come in. No, there is no question that has come in. Somebody has typed a name. Please. Okay, great. We'll move on. Now, where all a chartered accountant can sit as an arbitrator. These are only illustrative to find what it is. And before we decide on where a chartered accountant can fit in as an arbitrator, is that we know that in case of an arbitration where technical expertise is required, a technical expert can be an arbitrator, unlike a judicial forum where a judge, a judicial, a legally trained person alone sits to adjudicate the dispute. He may or may not understand. Incidentally, what was happening is that I'll tell you this. We have tribunals where you have technical member as well sitting. Now, if you take income tax appellate tribunal, you have a chartered accountant or a commissioner from the department can sit as a technical member, and he, along with a judicial member, decides. In case of SESTAT, also that happens. Now it's going on. Whether you'll have 4 member in an area tribunal or how many of them, and mostly 2 of them would be, 3 of them would be technical expert. And then you'll take, for example, NCLT, you have a accountant member, technical member, and you have also a judicial member. Now, when it comes to the S12 IPAB, Intellectual Property Appellate Board, you had technical member trademarks who used to sit along with the judicial member to adjudicate trademark issues. Why, in case of a copyright issue, a copyright member would come in, technical member would come in. Now this is what is happening. Now, in courts, you don't have all these experts. The same judge sits, he will look at, to whatever extent the lawyers explain to him, to that extent he'll understand and he'll start, passing orders. Now, as opposed to this, in England, they in IP subjects, intellectual property area, in the courts itself, technical members sit in addition to judges. In the adjudication process, it is not, consulting them. Okay, so that can happen. Okay, a way out. Now, second important factor in case why people prefer an arbitration to a judicial process is privacy and confidentiality of the parties. okay, where the amount is large, where it could name and shame could happen, a goodwill could be lost. And in those issues, it can be kept privately. The information could be confidential, and settlement can happen. All these are possible away from the public, this thing, so that the businesses can thrive and move on. Third is arbitration. Arbitral proceedings are more flexible in terms of procedure. They don't go strictly by the Evidence Act, and the procedures needs to be followed under the Civil Procedure Code, which are lengthier. And if you find, both the parties agree, arbitration cannot happen, need not happen on a particular day. They can agree to have, make it happen on some other day. An arbitrator can sit, if parties agree on even on a Sunday, to arbitration. And the arbitrations, sometimes go from morning 10 o'clock it starts and ends at 7 o'clock in the night, when evidences are cross-examined, when final arguments happen. It happens. But in courts, you can't expect that to happen. Now, cases like, where partnership disputes are there, you find that, happening more. Okay. When partners dispute are there, especially relating to accounts, when they say, mistrust, leads to partner disputes, like, he has been taking away money, the accounts is not properly maintained. In those cases, chartered accountant would aptly suit to sit as an arbitrator, because these are accounting related. Chartered accountants, by virtue of their experience as auditors and advisors to partnership firms and their businesses, there's what is done, what happens, is that correctly happening, is that accounted properly, is this a business where material could be sold, otherwise then the money is siphoned off either as cash or through other channels. Now, all this, when he has knowledge about those, it is easy to sit as an arbitrator and adjudicate the dispute. Now, the next one that can happen is that in case of a stock market dispute, when it is between the client and the broker, or one broker and another broker. Now, most of these disputes are where arbitrators are appointed by National Stock Exchange or Bombay Stock Exchange, and they have a panel maintained. Chartered accountants are best suited, because in case where stock market disputes are there, and so that they can easily adjudicate issues. And wherever financial transaction disputes are there, in all those cases, chartered accountant would fit in because of their rigorous training that they undergo, and the practice area is as such, they have expertise in that area. Now, in case of a tax dispute, now you'll ask me a straight question, don't blabber. What can he do in a tax dispute? Now, tax dispute are statutory in nature, and it can be adjudicated only by the appointed tribunals or by the courts. You're right in saying, but the tax dispute I'm referring to here is not the statutory appeals that are filed. Let me give you an example. Okay. Now, Mr. X supplies goods to me. I'm Y. I avail those goods, I purchase those goods, take delivery, I pay him money promptly as per the credit. Say 30-day credit. In 30 days time, I pay. Y pays X. Now, after making payment, Y takes input tax credit. Right? X said X does not deposit the money at all after collecting from Y. He is not filing even the return. maybe that he has undergone a financial crunch or a cash flow issue. Because of that, he is unable to pay taxes. Because he is unable to pay taxes, GST, he is unable to file either GSTR 1 or GSTR 3B. Okay. So he is not getting. Now we know the conditions under section 16 very clearly, that return has to be filed. It has to be now. It has to be available. It should be available as input tax based on GSTR 1 under 2A. Only then a supplier can claim ITC. Now, what happens in these cases? I've already availed the ITC. I have to reverse. What will happen to the money that I paid? The government will pressurize to reverse. That dispute is between Y and the government. Y can dispute saying that, this is wrong, this is impossible, all that is fine. And he can also say that I paid X, I'm not getting it back. Okay, he is supposed to pay under law. All that is fine. Government is going to say that, look, whether you paid him or not, that's none of my botheration. They can't say that, because within 6 months needs to be paid. But you paid or not, it is not my lookout. He has not paid me, so it has not come to the exchequer. Unless the money comes to the exchequer, how can I give credit to you? How can I give credit to you? These sort of disputes I'm referring to as tax disputes. And I'll tell you another instance. People have gone and they've said, look, I'll pay the government. I'm asking you, you pay me the money. That's all happening now. And there can also be disputes like, there is a back-to-back order which was taken by the principal contractor from the government, which is given to the subcontractor, back-to-back contract. Now, what has happened is that the TDS that was deducted by the government on the payment made to the principal contractor. The principal contractor is saying to the subcontractor that I will not pay you this money because it is deducted by the government, I will not pay you. Now the subcontractor has been again telling back and forth to the principal contractor saying that, look, government has deducted by virtue of a provision under the GST Act, CGST Act, that in case of a government, this thing, TDS needs to be deducted. But the contract between you and me, you are a private party, I am a private party, no TDS needs to be deducted. So you have to return me the entire amount. Now, this sort of disputes keep coming. Okay, these are tax disputes. And who can adjudicate these? Only persons who have sufficient knowledge in tax matters alone can adjudicate these disputes. It's allowed for a retired judge to sit, or a lawyer who's not trained, a judge who's not trained in tax matters, to sit and adjudicate these disputes. It's not going to happen. It's not going to happen. Okay. That's where chartered accountants again fit in. As arbitrators, they can sit as arbitrators and they can adjudicate issues effectively. The third is shareholders disputes. Now look at the oppression mismanagement would not fit in. Would not fit in because we saw that earlier, right? Oppression mismanagement would not fit in because that is not arbitrable. And oppression mismanagement is a right in rem, so it cannot be adjudicated by arbitration. But if you look at any shareholders agreement where private equity is involved or a venture capitalist involved, you will have so many rights reserved, minority rights, investment rights, information rights, and ROFR, drag and drag, all these will be there. You'll find an arbitration clause. And these would be to either take the money back. Let's say, for example, shareholders agreement is entered into, where optionally redeemable preference shares is subscribed by an investor. Now, being an optionally redeemable preference share, let's say that if it is at the option of the investor, when the investor makes a call for redemption, the preference shares has to be redeemed, the amount needs to be paid back. There is a dispute on this, whether penalty would come, will there be a liquidated damages, when is the date of default, all these issue comes in. More it is practically easier for a chartered accountant to sit as an arbitrator and arbitrate this matter. Probably, he can also sit as one of the arbitrators along with others, so that, it can also be a panel of 3, so that, where expertise from other fields required, like legal or, other another chart accountant sitting, fellow chart accountant sitting, or with an engineer sitting on board. It's easier. Technically, it's easier to do it. We were working on a dispute with Mitas club. Just roof was there, it was being the building was getting renewed, and the concretes done, here and there, as plasters were changed with the old lime layer plasters, because old heritage building. So the additional one that was done were through cement plastering, just changed to the lime. And there they had a centering and to be kept, and all these centers, poles fell down, so the roof collapsed. All this happened. This dispute, do you think, a legal expert would be well positioned to adjudicate? I don't think so. Rightly, the dispute was, the arbitration clause provided that it will be adjudicated by an architect, and the architect was the arbitrator, sole arbitrator in that, where we had to present, and he had his own understanding of what it is, and he went to the spot, unlike a judge could see what was happening, what could have happened, he could think of as a technical expert, and then, he passed an award. Like these specialized areas is where, technical arbitrators would come in, and chartered accountant, being a technical arbitrator, well versed in the field of finance, to be easier for him and to adjudicate these. These are only examples that I'm stating, which could be looked in. We'll come to the next one. Next one, where arbitrate, what services the arbitrator can bring in. Now, during the arbitration and after the passing of the final award, okay, by the arbitral tribunal. During the arbitration, he can audit. There could be a necessity to audit accounts when one of the reliefs sought in the arbitration is to render accounts. Okay, where disputes are there, real estate dispute, where money is the sole issue. In those as well, a chartered accountant can sit as an arbitrator, where there are loss of profit calculations. The chartered accountant would with suit. Let me give you an example of this to say so. A dispute between a landowner and a construction company. Okay. The landowner company is also, this is all these examples that I'm giving are all live examples. Okay. Only thing is that I'm concealing few names, just replacing names with some other name, so that you'll be able to appreciate it. Now, both the companies are corporate entities, and will known. Now, the landowner has put a claim saying that you have not constructed. I lost opportunity because of the negotiation that I did, the agreement that I entered into, I've lost. The construction company says that, look, the preconditions that we'll start a construction would be on these parameters, and the amount that we agreed on per square foot for sale of a constructed building apartment there for sale, say 15,000, whereas the other construction, people who came immediately after our agreement have constructed nearby in less than a kilometer distance. They've sold at 12,000, 10,000 and all. So feasibility as such to sell apartments at 15,000 per square foot will not rise. That's impossible. Because of that impossibility, the condition precedent is not satisfied. So we have opted out of the contract. Okay. If these sort of disputes are there, calculations, loss of profit, somebody has to certify these, they have to get in those. These are something that only a chart accountant can do it. In fact, we have used services of a chart accountant to value, to calculate loss of profit, all this, in these cases, and on. Where technicalities are involved, a chartered accountant could also be brought in as an expert evidence, either by the parties as a witness before the arbitral tribunal, so that they can be cross-examined and it can be ascertained, or the arbitrator himself can call for an expert evidence under the Arbitration Act from a chartered accountant, where it involves accounting related, finance related issues. Next is where valuations are involved. Now, when valuations are involved, unlike what we have in the Companies Act or under the Income Tax Act, rule 11 UA, we don't have to be a merchant banker, or we don't have to be an IBBI registered valuer when it comes to arbitration valuations. Chartered accountants can do that, very much, and there is no bar as such. Now, when we talk about after the passing of the final award by the arbitral tribunal, issues, when especially relating to partnership, when there are acquisitions that the accounts that were drawn earlier was not reflecting the complete picture of the partnership firm. In those cases, sometimes you might need accounts finalization as well, which could involve a little bit of redoing the entire accounts and representing it, and where fraud reporting is involved, those can be brought in. Now, all these would come under the execution proceedings, and then the execution process. This is where it can. Now, both of these, all the three functions, that I've referred to, sitting as an arbitrator, then lending evidence as an expert, third, the support services. All the three are equally important. I'm not saying one is important to that of the other, but all the three are important where a chartered accountant can make a mark. Now, when it comes to playing a role of an arbitrator, what are the things that a chartered accountant should keep in mind? What he should keep in mind. Okay. The two sections that he needs to keep in mind, section 16 and a batch of section 17 to 33. These are the two things that he needs to keep in. No. the arbitrator has a lot of powers. We saw interim measures, then the whole process needs to be looked at, hearing and, uh, process in the sense, more to service notice, so that, notice, the parties are put on notice. Otherwise, they can challenge it under section 34. Then completion of pleadings, allowing them, now I'll tell you this thing. Now, I have filed, we have filed a writ petition against MSME Council where arbitration is provided for. Because from conciliation, they directly passed an order, an award, a final award in arbitration. Though the Act provides for a conciliatory mechanism followed by an arbitration mechanism, arbitration has to be followed fully. Parties have to be allowed to complete their pleadings and to lend their evidences. And all these needs to be recorded. These are procedurally important. If there is fault in any of these, if these procedures are faulty or procedures have not been followed, keeping in mind the principles of natural justice, then naturally it would invite court's intervention under section 34 to set aside the arbitral award. Then witnesses, evidences, cost, decision, all these, something where an arbitrator has to, and these are things that he needs to look for before he could do it. Now, I'll tell you one more instance where an arbitral award was passed with a 12% interest rate. Then the arbitrator, once an award is published, we need to understand that the arbitrator becomes funcus officio. Now, when he has become funcus officio, he cannot recall, he cannot review his order. Now, what this arbitrator did is that the arbitrator changed the interest from 12% to that of 18%. The matter was taken to the court immediately. Not only that change, but the entire award goes for a toss. Now, that's very important. That's very important. So that can be there. So there is an authority gap that needs to be looked into, and every issue needs to be adjudicated by an arbitrator, unlike a judge. Judge can go with major, and with that, he can make conclusions. But an arbitrator has to adjudicate on every issue that is framed. Now, again, to recap you, though we have said at the start, the process is that parties have to submit themselves to arbitration. That is the reference to arbitration, then followed by the process, which is completion of pleading, then notice issuance, completion of pleading, then evidence and arguments. Okay, then the final one is writing an award and publishing an award. Publishing, as I told you, is to make it available to the parties. Could be through a post or call for a meeting and then pronounce it. That's very important. Roles of the court we have seen. I would focus only on section 34 to be very precise to you. I'll repeat it again. Now, where procedures have not been followed, where the principles of natural justice have not been adhered to, which means, notice to parties and then, hearing them, then passing an award, which is a recent award, meaning not just the conclusion, it has to have the basis, the rationale as to how did the arbitrator came to the final conclusion. Now, courts would not go to reappreciate the evidences. But if you have ignored a witness altogether, or if you have overlooked a particular witness altogether, then that would also amount to a violation of principles of natural justice. It would invite section 34 to set aside the award. No, that's very important, because well, if the awards are getting set aside, then parties would not come to that arbitrator. So that's important. So we understand this. Now, what are the roles of the parties and the representatives? Now we spoke about three major things, right? Which chart accountant can function like. One is an arbitrator, second is an expert, third is a support service. The fourth one, which is hidden, which is not told, is he can also act as a representative, meaning he can replace a lawyer and argue a case. But you can't do that in an haphazard manner. You can't say that, look, I've not had sufficient training, but I can do it, sort of. It cannot work that way. It has, because the whole evidences have to be appreciated. It's like being in a trial court. It's not a tribunal, where you can just go and just point out facts here and there which are documentary in nature, and the question of law. Here, evidences have to be appreciated, cross-examination has to happen, and finally, the award needs to be passed. So this is something that we need to keep in mind before we step in. Now, I was told that by 6:45, I can ask for questions if there are any question and answer, so that it'll be easier for members to participate and open up the floor. Now, before that, I'll summarize it again. We have a long history of arbitration. Even before the modern arbitration, it can be traced back to Brihadaranyaka Upanishad in the Vedic times, in the BCs. Now, next we find even in Tamil Nadu, in much before 1899 Arbitration Act, which is a replica of 1889 Act of the Britain of England, passed by the British for India. Even prior to that, in 1807, we have arbitrations done in Tamil Nadu, okay, in the Tanjore district, which also we saw. So it's not that it's something new, but the opportunities are coming afresh. Why opportunities are coming afresh? Disputes have always been there, but the financial related disputes have gone multi times after Corona. After Corona, it has gone up because people don't have money. They want to fight for even small things, and it's easy for them to do it. And what they look for is that they look for someone who has integrity and who's independent. Not only that, it's easy for them to talk to a person who's an expert in the area of finance, so that the disputes can be adjudicated with a lot of clarity, so that it could not be challenged. The only problem that we'll have is that the procedure needs to be followed without any flaw. If that is done, as arbitration awards cannot be challenged in appeal, the chances that the evidences could be reappreciated is very, very low, or negligible, nil. Chartered accountants emerge out in this scenario, to be fit to be an arbitrator, where that is also not happening. And that's why I've listed few areas where it can be partnership disputes, shareholders disputes, where stock market disputes, financial transactions involved. In all these, chartered accountants could play a very important role to act as arbitrators. Second is, He can also act as an expert evidence. Third, support services could be given. All these make up, fully. And the fourth dimension, which is like the unseen uh, head of the lion, fourth lion in the Indian emblem, like that, he can also represent parties in an arbitration forum. I think this summarizes the whole understanding of what we had this evening. And with that, I'll just leave the floor for any queries.
Sir, there is one question in the question box, sir.
Oh, 1 minute. I'll just go to it. See where it is. I'm here. Okay. How can CA offer services as arbitrator? Is there any impanelment? Today we have impanelment with NSC, BSc. Now, in that, chartered accountants can also be part of it. I don't know whether that's an open impanelment. Could also be a closed impanelment. We need to, from the institute, I think, to talk to NSC. There's a separate, impanelment, arbitration cell that is there in NSC. To them, we can talk and it can be sorted out. It's easier.
Sir, to become an arbitrator, because all the questions are answered, so until then, sir, become the arbitrator, whether the qualification of our certification course is enough, or we have to do certain separate courses for that. Is there any separate course for that, sir?
Certification course is enough. Only thing is that they need to try to understand writing award. An arbitral award is very important. Okay. Certification course is more than enough because I've seen it. It's good. So it's more than enough.
Okay. Sir, whether we need to register somewhere else, apart from it is not an empanelment. For example, when we qualifying as a CA, we are registered with our, when qualifying as advocate, you are registering with bar council. Like that, there is any administrative?
So your voice is lost.
Authorities for the arbitrator. Normally, hello. Sir, now it is audible?
No, it's audible.
Yeah, now it's audible, sir. You can continue.
Hello.
Sir, now it is, you can continue. It's audible.
Audible?
Yes.
Okay. Sir, for CAs, we have our institute, and as well as for lawyers, we have a bar council. Like that, there is any forum to administrate the arbitrator, sir?
No, there is nothing like that, as of today.
Okay. Mehta Kulkarni, sir, this empanelment, they need prior experience in arbitration. How can we shadow some arbitrators, sir?
Okay, you cannot shadow an arbitrator. Okay, because arbitrators have to be independent. They can only dictate to a stenographer to, who will, type out, whatever is told by the arbitrator. Okay, so you cannot shadow an arbitrator. What you can do is that you can shadow a counsel, a lawyer, a legal counsel. Through that person, you'll be able to see what an arbitrator is doing. The only thing that will not be visible to you is writing an award. That training can be assigned.
Yeah.
On that
As
training,
per the question, how can we get the experience, sir? So because some empanelment requires a prior experience, how can we show that we have experience in the particular field?
No, technical expertise is what they expect for empanelment.
Okay.
technical expertise is what they expect. Now, today, I mean, lawyers get impaneled, once they have certain exposure. Finance companies impanel lawyers. Same thing can happen, with the chartered accountants as well. Now, if you know the procedure that needs to be followed, then stock exchange, stock exchanges, brokers, finance companies can impanel you. Insurance disputes can also be adjudicated by chartered accountants.
Okay.
So you cannot have prior experience as an arbitrator to be in.
The fees charging is discretion of the arbitrator, or after, if there is any guideline is there, sir?
There is already there. Schedule 1 of the Arbitration Act has.
Oh, there's a guideline is there.
Yes.
So I think there is no other questions, sir. Raghuman?
No other questions, sir. All the questions has been answered, sir.
Okay. Can we go for the vote of thanks?
Sir, Arun sir, can you propose vote of thanks, or shall I do so?
Sir,
you propose the vote of thanks, no problem.
Okay.
Sir, thank you, sir. Satya, sir. Thank you.
Okay. Thanks a lot. It's pleasure.
Yeah, thank you very much, Satyanarayana sir. We have started this program with 10 participants, and gradually more than 65 participants have get benefited out of your this lecture. Thank you very much for your time, sir. Thank you very much. Looking forward for your continued relationship with SIRC, sir.
Thank you.
Thank you very much, sir. Thank you, Arun
Thank you, sir.
Thank you.
Thank you, sir.
Thank you. Thank you very much. Delegates, with that, we have come to the conclusion of today's CPE meeting on arbitration opportunities for CA professionals. We will meet on the next CPE meeting. Until then,
sir, one person raised, Raghuman ji.
Yes,
even
sir.
though this you are proposing vote of thanks, Mr. S. Vishwanathan, I have a question.
Yeah,
sir,
yeah,
kindly
yes.
type your question, sir.
Yes, sir.
Sir,
Vishwanathan, sir.
Satya, sir, you are available? Satya, sir, available?
Yeah, I'm available. I'm available. I'm there.
Yeah.
Vishwanathan, sir. Yes, Vishwanathan, sir. What is your query, sir? Vishwanathan, sir, are you there? Yeah, yes, Vishwanathan, sir, you are very much available. What is your question, sir? I can see you in the list of participants. What's your query? You can type on the Q&A, sir. Advocate, sir, is extending his time to answer your query, please.
This meeting was to
explore opportunities for CAs. This meeting was to explore opportunities for CAs. Can you elaborate?
So definitely, Vishwan sir, that's what I was summarizing.
Yeah, actually, this meeting is all about opportunities for CAs. That is what Mr. Advocate Satyanarayana sir has been briefing all along, sir. Okay.
Okay.
He is already aware of the act.
Okay, I've not told you about the act. What I was trying to tell is that, the role that a chartered accountant can play is of 4 different. One is that he can sit as an arbitrator, for which he needs to know the procedure, the way that it can be challenged is only under section 54 to set aside an award. Only when the procedure has not been followed properly. Because if you look at all the 5 grounds that are there, section 34, mainly on the procedure. Second one is that the arbitrator, not just an arbitrator, he can also be an expert evidence. The arbitrator can call for an expert evidence, so he can be. And the third is that, he can also render support service, like, the accounting services, the audit services, fraud examination. Fourth is that, he can also be a valuer, loss of profit calculation. All these are, something that he can do as a support service professional in case of an arbitration to either of the parties, claimant or the respondent. The fourth one is he can himself act as a counsel, advise, clients on arbitration and appear and represent on their behalf. The last one is unknown phase, maybe a difficult phase too, but the other three are very much done. Okay. When it comes to empanelment opportunities, I think, we need to open up that with financial services, industry to do that. NSC has, BSc has one. That needs to be, where chartered accountants could get in. That's one opportunity where it can happen. The second one is that, we can also explore to get in for financial services firms where it can be done.
Okay, sir. I think so. Almost we answered everything. Raghumanji will close the.
Yeah, sir. Yeah. Thank you,
Sir, thank you,
Vishwanathan,
sir.
sir.
Even though after what of thanks, you have spent your time and answering few queries. Thank you, Satyanarayana, sir. Thank you, sir.
Thank you.
Thank you very much, sir. Thank you, Vishwanathan, sir. A special mention for your active participation and your questions. Thank you very much. Thank you, one and all.
Thank you.